So now I've got the amazing Sandra Glazier on what she's going to talk about.
Hello. In today's environment, addressing issues relating to the potential loss of capacity or actual loss of capacity are in the headlines and are issues we as estate planners have to address on a regular basis. Some might say this is like dealing with lions, tigers, and bears. Oh my. And why do we say that? Because there's no one fits all solution to an individual situation when capacity issues are presented. The move today is towards supportive decision making. And even when more restrictive options are utilized, the goal is still to consult with the individual and have them participate to the greatest extent possible. But understanding the options that are available to us as attorneys, whether it be in a proactive estate planning situation or reactive situation because the loss of capacity has occurred and plans either were not put into place or because of dysfunction in the family, additional protective barriers may be required, or because the client does not or individual does not recognize their own limitations and continues to incur debt or place their assets in jeopardy. It's important to understand the options, when they work, when additional protections may be required, and how to properly advise the client and the considerations that they may wish to address. So at Notre Dame this year, my presentation is going to focus on these options and discuss the pros and cons of supportive decision-making agreements, powers of attorney, designations of patient advocates, the use of protective clauses such as Ulysses clauses and other protections within one's trust, as well as court processes that may still be required, and the importance of limiting the extent of those court processes to only those remedies necessary to adequately address the limitations of the individual. There may be times when a fiduciary who can act under a power of attorney because of dysfunction in the family may feel that they don't want to have a situation where the statute of limitations over actions they're taking doesn't begin to run and may be extended for years, decades, before the rights of other individuals to challenge those actions are triggered. And in those instances, it may be the fiduciary who decides that some limited intervention by the court may provide the protections necessary in order to trigger a statute of limitations or get the court's blessing with regard to proposed actions. These are really important issues for any practitioner to understand, because most of us, as well as our clients, are not likely to die not having suffered any diminishment at any period of time during their lifetime in their capacity. It may be a loss of capacity for a very limited period of time because of a medical procedure or situation that may dissipate over time. Or it may be a lack of capacity or ongoing diminishment in capacity that occurs and lasts for the duration of that individual's life, with some fluctuation, improvements, and decline over that period. I hope that you will join us at Notre Dame as we discuss this important area of the law and not rely on the sensational headlines of famous individuals who've had to go through probate proceedings in order to address these issues. Not all processes are bad, nor are all processes good. It is fact dependent, and understanding how those facts and options may interplay will help you be a better planner in addressing your client's needs.
I think that is the single most important topic that any of us in any of the allied estate planning professions should be talking about, because this is something, and Sandy mentioned just some of the headline items without using names, and I'll leave it like that. But what we see in the headlines is not even the tip of the proverbial iceberg. There are too many terrible horror stories of people with diminished capacity having their lives ripped out from under them. And this is really something we all need to focus on more. With the aging population, with the incidence and increase of dementia and other issues as clients age, chronic disease, this is really a crucial topic. And I think that this is the kind of topic that needs real attention at conferences. We tend to focus and get excited about some sexy new estate planning technique that maybe Alan or somebody else has come up with, but this is at the heart of planning for human beings. So kudos to Jerry for even including this, and Sandy's brilliant. So I know it will be a great presentation.
Absolutely. Okay, now the life insurance gurus.
Let me make one comment here. One of the problems with life insurance is it is awesomely complex, and the insurance company illustrations are estimates. That's all. No insurance company illustration ever produces exactly the way they illustrate it. And the problem is we are all basically, our clients are relying on us for advice. And so what Barry and Rebecca are going to do is basically just give you some insights on how to go about dealing with life insurance proposals that your clients receive. It's all really understanding what the insurance policy can accomplish, and whether those objectives in the insurance policy are consistent with the objectives of your client. Because no one policy is good for all. If you want to maximize death benefit, you get one kind of policy. If you're looking for, increasing the rates of return, you get other kinds of policies. And that's really what they're going to do, is help you evaluate policies and also explain your duties to clients when you are giving them, they're relying on you for advice and what you have to do. Thank you.